ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ?
ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಿದೆ ಸರ್, ವಿಡಿಯೋನೂ ಇದೆ ಕ್ಲಿಯರ್.
ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.
18. 18 someone mentioned. Huh? Then all these matters has to be adjourned. Correct. There may be some other matters also, Muttanna's matters. 21, 23.
Serial number 19, Lordship.
Matters to be adjourned.
Lordship, serial number 19.
On the other side, because some matters were listed specifically. The other matters, it was these matters were listed specifically. This 22, 21, 23. Then
Lordship,
21, you are appearing for Mr. Muttanna, na? 21, then 23. Some important question of law was required to be decided. At this request only the matters were listed. All these matters, these matters after summer vacations 2022, as prayed by the learned counsel appearing for the petitioner.
Lordship, serial number 19, Lordship. Yes.
19.
Please, my Lordship. And for respondent,
We are appearing for
I paid for respondent in 19 and 19.1 and 19.2 I am for petitioner. I fixed time for filing objections, my Lordship. We kindly have it after summer vacation, my Lordship.
this matter after summer vacations at the request of the learned counsel appearing for the petitioner in petition number 12358 of 2021. Kindly inform Mr. V.S. Naik.
I'll do that. Yes, my Lordship.
Serial number 26.
Yes. For the petitioner, yes, after summer vacations 2022, at the request of the learned counsel appearing for the petitioner.
Your Lordship, serial number 26.
26.
My lord, I appear for the petitioner in this case, my lord.
Appearing for the respondent.
On the last date also, they had taken time, my lord. This is a covered matter.
Your Lordship, the documents that was requested, we have it was still not handed over to us, Your Lordship.
So we will not adjourn matter, madam. This is 2012 matter. On the last occasion only, we had made it very clear. We will not adjourn this matter. Sorry. Yes, next.
Obliged.
Serial number 31, my lord.
28, my lord. Lord Satyanand is not keeping well. This request, my lord, after vacations for the appellant.
After vacations.
Please, ma'am.
Sir, learned counsel appearing for the appellant.
Obliged.
Yes.
My lord, serial number 31, my lord.
27. How many times the matter has been adjourned, madam? Not adjourn the matter. Sorry. At your request only the matter is listed. Sorry, will not adjourn this matter. At your request only the matters are listed today. Yes.
31, my
Sorry,
lord.
madam.
Serial number 31, my lord.
Yes.
Whereas batch of the validity of the provision 51A of the GST Act has been challenged, my lord. In one of the serial case number 31.3, my lord, your lordship has passed a judicial order most before the roster bench, my lord.
Then again, why the matter is listed here?
I don't know, my lord, because in the first case there may not be a judicial order, my lord, which was in 2021 matter. Maybe
So the
posted
opposite
after.
court having a roster.
Serial number 30, my lord.
Yes.
Give up the respond.
Sorry, we will not adjourn this matter, sir. How many times we have to adjourn the matter? Sorry. Whatever it is, will not adjourn this matter. Sorry, sir. Sorry. Sorry, sir. Next time granted to do the need. Granted to do the need. Huh? Seventh office objection, non-filing of typed copy of manuscript form. What is annexed? No, it's all, it is not at all legible, sir. If you make it as a part of the record, it is not, is it not required for it? Whatever it is, sir. Then why did you make it as a? So if to complete it, then you have to make it available. The typed copies also should be there in the record. Otherwise, it's very difficult us to follow what is there. At present, you may not be relying upon. Then why should you make it as an annexure? Sorry. If you file it, then we will consider it, sir. A week's time granted, we'll consider it. File. We direct the learned AG to us. But in the meantime, you comply with the office objections, then we'll consider it. Where is government advocate? Yes, that the copies are served on you. Learned AG, learned AG accepts notice for the respondent. The appellant to comply with office objections. It's the matter by next week. Orally, you would request the department, but we will not pass any judicial order. It's the matter by next week. Comply with office objections.
Your Lordship, appearing on behalf of the petitioner, Your Lordship, this matter has to be connected with one more matter. Your Lordship. The same submission was made last time also.
Yes, what
But
is
the
the number?
matter is
Give the number, madam.
424 of 2017, Your Lordship. STRP 424 of
This matter along with STRP 424 of 2017 by next week.
Much obliged. Yes. Forward. No, sir. Why it should be kept pending here? Yes. Yes, yes.
May I submit, my lords? My lords, I am appearing in three items, my lords. My lords, first, my lords, I have not received the copy of the appeals filed by the department, my lords.
You are, what is your good name, sir? You are appearing for whom?
Associated Mining, my lords. My lord, there are tagged appeals, my lords. In three appeals, my lord, the learned senior counsel is appearing, and for some erstwhile partners, and I am appearing for some other partners, my lords. And I am the person, my lords, who has
Copies
filed-
are already served, sir. It is for your client to submit the papers to you. It
lords,
is not
I-
for the Learned Counsel for the revenue
I
to
agree,
submit
my
the
lord.
papers to you.
My lord, this is a
Once the notice is issued and it is duly served on the party, it is for you to collect the copies from your party.
My lords, my lord, it is not served on the party because the company has changed the partner to new. My lords, may I submit once?
It is served.
My lord, may I
It is
submit once?
fully served, sir.
My lord, may I submit once? My lord, the company has changed partners. It has been served to the other partners, not to my clients, my lords. There have been different partners in the company, and this company has changed hands. And that is why the department has made the erstwhile partner, which is represented by the learned senior counsel, Mr. Shankar, and my clients, my lords. So for a particular period, there were certain partners. For a particular period, there were some other partners. So they have served on the other partner. That is how the registry is showing the service to be complete. So far as my clients are concerned, my lord, there is no service. And my lord, I have also filed.
As far as all parties are concerned. Kindly look at the causes now in ITA 712.
Yes, my lord.
R1 Messrs. Associated Company, Mining Company, Bengaluru served. R2 Messrs. Associated Mining Company, Bangalore served.
Correct, my lord. Now, associated companies, my lord, consisting of, I am not presently partner in the company.
We are not concerned who is the partner. It is served duly on the
My lord,
consent.
but now the appeal is against me. I am no more partner in this company. This company was earlier belonging to me, my
Not
lord.
against the partners, sir. It is against the company.
My lord, the name is only company. It's a partnership firm, my lords. The name is only Associated Mining. It's a partnership firm.
Maybe so, but it is not the company, not the partner associated partnership firm.
Yes, my lord, it's a partnership
The
firm.
company and the partnership firm.
My lord, it is the partnership firm today also, my lord. Only it is name is Associated Mining Company.
File code ITA 712 of 2019. 712, sir. Yes. It is duly served. Messrs. Associated Mining Company. Oh, it is served on whom? What is the name here? It's served on 24/1/2020. Erstwhile partner Srimati KM
Parvat my lords. That is the client of Mr. Shankar, my lords.
Subsequently, last statement was amended, fresh notice was issued, that notice is served.
erstwhile partner Srimati KM Parvathamma and Sri KM Vishwana. Then you amended the past title.
Amendment application was allowed. On that,
It is served on whom? Subsequently.
not associate enterprises, partners,
Gali Janardana Reddy. Erstwhile partner Srimati Gali Lakshmi Aruna.
My lord, these are my clients, my lord.
Served on them, sir.
Not on the
Lord,
same
I-
position, not in respect to any periods of previous partnership. Same position, not in multiple times, not the matter of. Never made this.
My lords, I got to know about this matter for the first time. That's why, my lords, I am today appearing. All I am requesting, my lords, may kindly give me 1 week's time. I'll take the copy, my lord, today itself. And in this matter, my lords, as I have been told recently in the morning, my lords, I have also filed a review petition. Since the order which has been set aside by the High Court was only on one ground, that is on a technical ground. With respect to the other grounds,
At liberty to you in case that review petition is allowed, then you are at liberty to revive this appeal.
so all my lords, at least give me 1 week's time, my lords, to have the copy of the appeal at least so that I can argue my case, my lords.
What is your good name, sir?
Mayank Jain, my lords.
Huh?
Mayank Jain. Mayank Jain, my lords.
J.
I am Jain. My Jain.
No, just he is seeking for a week's time. We will grant one time. That is, we will list it on 19. We will list it on 19. We will dispose of it with an understanding that we will dispose of the matter on that day. But again, don't seek time, sir. Mr. Jain.
My lords.
Mayak Jain.
Mayank, M-A-Y-A-N-K, my lords. M-A-Y-A-N-K, N-K.
You are from Bangalore, Bar. From Bangalore.
Delhi bar. I'm from Delhi.
Learned Counsel Shri Mayank Jain undertakes to file power on behalf of the respondents in ITA number 712 of 2019 and ITA number 715 of 2019, comma 71 first comma hakoli 715, then and 717 of 2019. That is 712, 715 and 717 of 2019. This is the matter on 19th April as prayed. No further adjournment on that day, sir.
My lords, deeply obliged, my lords.
Notice interim order as prayed for. Court officer. Court officer. This matter along with 38 of 2022. Issue notice.
Questions about all independent issues arising out of this matter. So first question, my lord.
53.
Any other side, it may have to be answered. The principal upset about the earlier.
First, we issue notice like in these matters of let it be considered. Notice.
There are questions with
Notice.
the 9 is same as 7. Notice. It is not the same as 8. Notice.
Notice.
11 after is similar matter, only one question, but that has already been admitted. That was similar if the lab proceedings the percentage of the time limit something agreed that can be applied beyond the period of time. The double taxation agreement, there are two alternative dispute resolution mechanisms. There is one agreement, another is mutual agreement procedures. Which will be not agreed between two competent authorities and both the countries. With that contract will not be subjected to an agreement. But whether the conditions agreed regulation that we are
Whether it forms a substantial question of law here.
otherwise not the agreement.
Notice will not admit.
Even if, for example, if no other one issue is settled, that cannot be, but the course of the law to be. That is the. In fact, the connected matter is on for the treated on the same.
Consider it, let the other side of it. Covered a 48 day 2, 3. Yes. Matter it is admitted. Yes, assessment. And the counsel, Shri K.V. Arvind is permitted to accept notice for the respondents. We'll admit this matter. But the appeal is admitted to consider the following substantial questions of law. One, this matter, along with the ITA number 169 of 2020. The copies to the other side. May 2019 is the date of the order, sir. Huh? The order of the order date is 20th May 2019. Why this is now listed for admission? February 2020 you have filed it. Then why you have not moved it for such a long period? Office objections were there. When you have complained with office objections. Now it is ready for admission. Times, yes. You have complained only on after the order passed on 3rd of December 2021. Correct, sir. You have taken 1.5 years to comply with the office objections. What is the order passed by the CGIT? What is wrong with it? And also the case of from December 2000 to 6/6/2004, and after a break, you have worked only for another 74 days. That's all. Yes. It's not a case for reinstatement, sir. Notice.
One case development told by the legal base. No, sir. Appeal number 17 and 18 of 2020 decided on 23rd.
Pass the order copy.
I'll see the order.
Yes.
22/2020. And give the order.
This intra-court appeal is directed against the order dated 2nd December 2021, passed by the learned single judge in writ petition number 21882 of 2021. But this Asia Paints Limited has been confirmed by the division bench. Whether this is the division bench judgment which has been followed or the single judge's order. No, this is the Union of India versus Asia Paints. That is a division bench order. Reported in 2021 49 GSTL. Whether the single judge's order, kindly find out
This is
the DB order.
this is a DB order. 2020.
Because the revenue has preferred the appeal before the DB. Court officer check ಮಾಡಿ. And we find that the reasoning of the learned single judge and yes, whereby the learned single judge has passed the division bench decision of this court in the case of Union of India versus Asia Paints Limited and others reported in 2021 in practice. DSTL 256. And thereby permitted the respondent assessee to file the rectified Tran 1 form electronically or manually within a period of 30 days from the date of the order. The learned AGA the controversy involved hearing no more recent ground in view of the bench decision of this court in Asia Paints Limited and others referred to Supra. Having regard to the coordinate bench decision of this court, we find reason to interfere with the order of the learned single judge, more particularly when in number of cases filed by the revenue, identical circumstances have been disposed of following the said ruling of the division bench referred to Supra. In view of the aforesaid, it appeal stands dismissed. Yes. There are certain office objections are there. Typed copies of annexes. We can dispense with the translation of the annexes, sir. But the typed copies, sir. What's the matter?
Indicates that there is no nala at all. 178. But is the red one. On the reverse 24 blood might not take the count. 21 the side is red. There is no nala. The Tahsildar initiated proceedings. Matter was not we filed the resolution for my part. That part has alleviated.
At
That is it, and the matter is still pending. During the pendency of this proceeding, the land grant report on the basis of newspaper.
So what is this Siemens Limited versus State of Maharashtra and others referred to by the Writ Court in page 83? Page 83, there is a reference to Siemens Limited versus State of Maharashtra and others judgment.
Already besides that, there is what had happened there was Tahsildar said you are already there is an encroachment. If you already made up your mind, the show cause notice has to be elements at all. You will not pass the final order.
So the emergent notice was issued there, but thereafter the matter is correct, sir. After the issue, still pending. After issuance of the emergent notice.
And what the land grant report not Visa by a large form. Land grant report land grant report not say there is one they cannot therefore I will come. All people are 91 years, 92 years, and all right is given by this legal land, not my land. It is given on legally constructed records with the science land.
Where this land is situated?
The lease people are distributed by the media. It's a media land, not my land. We cannot lease for 30 years.
You have a copy of this writ petition, sir? Writ petition 551 of 2006. Check ಮಾಡಿ stage check ಮಾಡಿ 60 551. There are other two petitions referred to therein, 8896 and then.
The note said that the file of objection. It issued no passing.
2016 ಅಲ್ಲಿ ನೋಟಿಸ್ ಅಂತಿದೆ, ಆಮೇಲೆ ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ ಸ್ಟೇ ಬಗ್ಗೆ. 16/12/2016 ನೋಟಿಸ್ ಡೈಲಿ ಆರ್ಡರ್ಸ್.
If this annexure Q, the order sheet, there is a reference to that 27/1/2017 order. Tehsildar Bengaluru South Taluk is present and submits that the Honorable High Court of Karnataka has extended the stay order till the next date of hearing. That matter.
They were granted us the sanction plan. We have constructed the hospital. For the last 14 years, the hospital is being we could not take us to that practically to the whole of Rajasthan to that this is to all the area. They are not seeing the we informed the hand carrying. But when a higher court is to matter, those do not
that you have challenged the virus of the order along with others.
What happened was this issue was not considered short. But I got along with them. Our review petition is pending. What happened was
but once that is dismissed, sir.
What happened is we did not challenge this order. We did not challenge the validity and virus. Other than that, was not. This on the top of validity not update. Yes. But whether or not and is seized by a lot of support not in this meeting proceeding was not wanting. That's why we are not.
No, how can we entertain another petition on the same by the same petitioner when you have already challenged that validity? So if is it maintainable, sir? If you already yes. No, can repeated petitions to be filed by a petitioner that on one ground not raised in the earlier petition? Already the proceedings were initiated before the special court. When you have challenged the virus of the order. Yes, sir. Now, what is the order dated 22/3/2022? That you would have challenged it, sir, in a comprehensively in one writ petition, not filing repeated writ petitions like this, sir.
What we are challenging.
What happened? Here repeat.
Notice 16/12/2016 ಅಲ್ಲಮ್ಮ?
ಇದೆಯಲ್ಲ interim stay as straight for ಅಂತ ಫಸ್ಟ್ ಗೆ ಇದೆಯಲ್ಲ ರೀ interim stay as straight. Issue notice. Interim order as straight for to the next date of hearing. Is the matter immediately after summer vacations 2022. We will this dispensation we will allow typed copies can be filed. Production of translated copy of annexure is dispensed with at present. IA2 of 2022 is allowed. First ಹಾಕೊಳ್ಳಿ ಅದನ್ನ. To notice then interim order of stay as paid for to the next date of immediate after summer vacation 2022. In the meantime, the other office objections to be complied with. Now, what is the date of the impugned order, sir? Annexure D. That is dated 27th August 2020. Why after 2 years now you are before this court? And why you are not complied with that office objection? Then why it is shown as petition 7679 of 2022? Court officer, why it is shown as 7679 of 2022 when it is filed on 4th January 2021?
4th January.
2021 it was filed. Seven 679 of 2022 and it is shown.
For number 182 of 22 ಇದೆ. Office objections are comply ಮಾಡಿದ್ದು 1712 ಅಲ್ಲಿ.
17/1 2021 ಅಲ್ಲಿ.
For number 21 ಇದೆ. ಆಮೇಲೆ round of 122. For 182 of 21. Several complaints.
The file was lying here for complaints of office objections nearly for more than a year, sir. It shows your yes. Then why you have not complained the office objection?
fine. One petition is already come before the bench and it is numbered as 10377.
Yes. Pass out. 18, What is a urgent meeting? So that ಏನದು ಇರುತ್ತಲ್ಲ ಆ 11
you listed down the schools that are referred by law to the labor code and the industry. Very well, with regard to service condition, very with regard to minor punishment, it may be with regard to dismissal as a workman. Then there was a power to the labor code.
No, we wanted to hear this matter with Mr. Mutanna's matter. Mutanna and Vedmurthi's. Avare heliddu. Now it is urgent. Today is Mr. Mutanna is not keeping well.
I wanted to make the guidance on the what is the position of the as Supreme Court files for this matter? It is a two cases judgment, but even till today, there is a landmark. Now, let us one paragraph of the other now,
ಅದನ್ನ ಆಫ್ಟರ್ ಮಿಟೇಷನ್ಸ್ ಅಂತ ಮಾಡಿದ್ದೀಗ
go to page number 17. ಏನಾಗುತ್ತೆ ಕ್ವಶನ್ ನೋಡಿ page 17 ಮೇಡಮ್ ಕೆಳಗಡೆ ಟೈಪ್ ಪೇಜ್
even they are also relying upon this firestone only. Some para?
Page 17.
Page 17. Yes, sir.
The stage at which, third line, the stage at which the employer,
Page 17.
Third line. Yes. The tribunal to allow him to accuse evidence before it has also been discussed in the sentencing. We have extensively, exhaustively referred to the various decisions of the court as they give a clear picture of the principles governing the jurisdiction of the tribunal when adjudicating disputes related with dismissal or discharge. Those decisions, the following principles broadly emerge. The right to take disciplinary action and to decide upon the quantum of punishment are mainly managerial function. But if a dispute is referred to the tribunal, the latter has power to see if action of the employer is justified. Before imposing the punishment, an employer is expected to conduct a proper inquiry in accordance with the provisions of the standing order, if applicable, and the principles of natural justice. The inquiry should not be unconformed. Next important. Next. When a proper inquiry has been held by the employer, and the finding of misconduct is plausible, conclusion flowing from the evidence and inquiry, the tribunal has no jurisdiction to sit in judgment over the decision of the employer as the applied body. The interference with the decision of the employer will be justified only when the findings arrive at the inquiry are perverse or the management is guilty of victimization and therefore tax. Victimization is punishable, not unfair. Authority no power to reduce the penalty, minor penalty. Dismissal is just a wide power. This is what I know because it requires some. victimization it requires some consideration. Immediately. Prior to other loss may see appreciate. Yes.
The question, the arguments the other side put forward on the other day was when there is an order of a minor punishment, the tribunal has no power to reduce the punishment by invoking section 11.
You know, my lord.
It is a standard order.
I take two more minutes time of the lord. Yes. No, my lord, prior to amendment to section 2A, 2A insert Marigaga, individual workman can measure dispute.
Yes, yes.
That is what the aim to power of only the union industry escorts property. Whether it is in respect of collective dispute, in respect of minor punishment, or in respect of major punishment of dismissal discharge. Adjudication for what was the powers of the court in Bharat number of including theoretical and victimization number of judgments. It depends on the number of judgments. When Madras High Court is the I read one. He says the how this adjudication should take place. Anyway, victimization is there. Ultimately, victimization I'm telling you. Different way, saying that the court has exercised powers, holding that the punishment of 5 increments is like a victimization. So I read it here. Assist my court here. I have no problem. And I will be welcome. No problem. Welcome.
These are all settled, well settled issues, sir. No.
See that Bharat elements no video fight ಅಲ್ಲಿ ಯಾವಾಗ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು ಅಂತ ಅವರು ಕೇಳ್ತಾರೆ ಇಂಟಿಮೇಟೇಷನ್ ಅನ್ಫೇರ್ ಪರ್ವರ್ಸ್ ಫೈಂಡ್ maybe malad fine intimate perverse findings is what we have any inquiry is failed now there are two stages in inquiry not should talk today failures of the inquiry
Now kindly come to page 18 in this five stone case. Kindly come to page 18. In a middle para, that is the question is whether section 11A
question is whether section 11A has made any changes in the legal position mentioned above, and if so, to what extent. The statement of objection, the reasons cannot be taken into account for the purpose of interpreting the plain words of the section, but it gives an indication as to what the legislation wanted to achieve. At the time of introducing section 11A Act, the legislature must have been aware of the data in the various decisions of this court referred to above. The object is stated to be that the tribunal should have power in cases where necessary to set aside the order of discharge or dismissal and direct reinstatement or award any lesser punishment. The statement of objection and the reasons are specifically referred to in the limitation on the powers of the industry tribunal as laid down by this court in Indian Iron Steel and Company Indian Iron Steel Judgment. This will be a convenient stage to consider the contents of section 11A. To invoke section 11A, it is necessary that an industrial dispute of the type mentioned therein should have been referred to an industrial tribunal for adjudication. In the course of such adjudication, the tribunal has to be satisfied that the order of discharge and dismissal was not justified. If it comes to such a conclusion, the tribunal has to set aside the order and direct reinstatement of the workman on the The tribunal has also power to give any other relief to the workman, including the imposing of minor lesser punishment, having due regard to the circumstances. The proviso has a duty on the tribunal to rely only on the material on record. The material on record is some high court and must expand my head that TDC was record and probabilities it won't take any such evidence. Even a mere reading of the section, in our opinion, does indicate that a change in the law, as laid down by the court, has been affected. According to the workman, the entire law has been completely altered, whereas according to the employer, a very minor changes has been affected, giving power to the tribunal only to alter the punishment of having held that the misconduct is proved. That is, according to the employers, the tribunal has a mere power to alter the punishment after reports that the misconduct is proved, the workman on the other hand claims that the law has been rewritten. This is next to the we cannot accept the extreme contention advance on behalf of the workman and the employer. We are afraid that is a beneficial piece of legislation enacted in the interest of the employees is well settled that in construing the provisions of the welfare legislation, courts should adopt what is described as a beneficent rule of construction. It proved reasonably possible to be based on the section. It follows that the construction further the policy in the object of act is more beneficial to the employees has to be preferred. Another principle to be borne in mind is that the act in question which 1958 Supreme Court 667. I think 59 Supreme Court Federal Court what is the power of the labor court? I mean, tribunal in the labor court. It's a 7 judges judgment 1959, 1949 and 1950 Federal Court. It has to improve and safeguard the service conditions of the employee. Service conditions for the implement especially service conditions of an employee demand an interpretation liberal enough to achieve the legislative purpose. But we should not also lose sight of another canon of interpretation that a statute or for the matter of that even a particular section has to be interpreted according to its vague words and without being violent to the language used by the legislation. Another aspect to be borne in mind is that there has been a long chain of decisions of this court referred to exhaustively earlier, laying down various principles in relation to adjudication of disputes by industrial courts arising out of orders of discharge or dismissal. Therefore, it will have to be found from the words of the section whether it has altered the entire law as they were by decision, and if so, whether there is a clear expression of that intention in the language of the section. We will first consider the therefore, my submission is in case of dismissal, discharge, retrenchment, there is a cessation of employment law, revenue is not applicable. Revenue is applicable. That is the revenue. Earlier to that law is available. There is why? How can the government afford a dispute? It is a reference of industrial dispute. Is according to threefold. One to collective dispute. One individual workman's minor punishment. ಇನ್ನೊಂದು dismissal discharge. ಎಲ್ಲರಿಗೂ ಪವರ್ ಇರಲೇಬೇಕು. Otherwise, why should the government afford a dispute? Now, section 10 downwards, section 10 and 12. Incidental power is section 10. Section 10(4) says labor code has got the incidental power. So, you ask the revenue ಬರೋದಿಲ್ಲ in case I have fully accepted. But the utilization of the practice, even right from PH even in the Daegu Jilla case, even the 32 victimization and practice, even the 30 last dismissal order pass ಮಾಡಬೇಕು ಅವತ್ತಿನ ಟೈಮ್ನಲ್ಲಿ ಪೇಪರ್ ನ ಕಳಿಸಬೇಕು ಅಪ್ರೂವಲ್ ಅಪ್ಲಿಕೇಶನ್ one month wait ಮಾಡಿ these should be simultaneous. Yes, there is no quarrel about it. ಅದಕ್ಕೆ therefore you cannot expand ಅಂತ ಹೇಳೋದಕ್ಕಾಗಲ್ಲ. 32 I can still question inquiry is not fair. I can still question it is victimization. Otherwise at Williamson matter case Supreme Court said the victimization will not be for day-to-day activity. Even if the excessive punishment is imposed, it is victimization. So, victimization ಅಂತ ಹೋದ್ರೆ ಫೈಂಡಿಂಗ್ಸ್ ಒಳಗೆ ಪರ್ವಸಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟಕ್ಕೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸ್ಟಾಪ್ ಮಾಡಿಲ್ಲ. The findings are fine. In the case of victimization under your practice, what can you do? Otherwise, the other minor punishment is there. Then there is no adjudication required by the labor court on it. Available position change power in the labor court. It may lack of victimization. In such cases, court can interfere and lesser punishment without back wages, some portion of back wages, withholding of increment. Labor court not increment cut ಮಾಡಿ ಅಥವಾ very minor punishment very warning ಮಾಡಿದ್ದಾರೆ. Always power and such. Yes, I fully I have no view, whatever. Nobody can have a whatever. Key point victimization ಅಂತ ಹೇಳೋದ್ರಿಂದ court and the tribe, labor court or the tribunal has got a power. By adjudicating an industrial road, that it can interfere in respect of even a minor punishment if it is by the victimization, unfair practice, then it is not bad. Labor court has the jurisdiction.
It was never canvassed.
And the proportionality.
Only ground on which the tribunal has indicated is that there is no financial loss. No market victory.
So where is the judgment of this Bharat Bhushan Union Bank of India versus Bharat Bhushan referred to by the tribunal? Anything. Their lordship envisaged under what circumstances the tribunal can interfere, even invoking section 11A. So where it is, where it shocks the consciousness of the court. There is no. Now 5 increments, reducing the punishment of stoppage of 5 increments is modified to 3. Is
Reasons are assigned in this case. That is a very serious in nature.
here, what are the charges?
ಸಂಬಂಧನೇ ಇಲ್ಲ. ಇದು ಕಂಪಲ್ಸರಿ ಟ್ರೀಟ್ಮೆಂಟ್, ಮೈನರ್ ಪನಿಷ್ಮೆಂಟ್ ಅಲ್ಲ.
Page 17. What is the if you are elected surrounding the co-creating bank manager, you need to refer to bank manager and show that using derogatory and insulting language to present for that and that is police. You will allow to prove to customers. 30 on 33/2001, we give the respect. Authorizations and instruments. Not implementing the decision by
The misconduct is this not of moral turpitude or causing financial loss to the second party bank. Whether in this Bharat Bhushan case, Union Bank of India versus Bharat Bhushan, this Firestone has been considered. Firestone has been considered. ಅಲ್ಲ ಇದೇ ಅನ್ನಲ್ಲ ತಮ್ಮ ಹತ್ರ ಇದೆ.
ಈಚೆಗೆ ಬಂದಿದ್ದೀನಿ ಕೇಸಿನಲ್ಲಿ. ಅದು ಯೂನಿಯನ್ ರೆಫರೆನ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅದು cannot be allowed to.
Now, what is the citation of this Union Bank of India versus Bharat Bhushan? Court officer. Union Bank of India versus Bharat Bhushan. It is decided on 23rd April 2015. Antar. What is the citation? Whether it is reported? The number, at least there should be number in a read back. Both of you. Huh? No, that the labor court has mainly, tribunal has mainly relied on this judgment to come to that conclusion, nothing else. Based on, in the light of this judgment, the tribunal has held that it is a fit case for interference. Now, let us see that judgment which has been followed by the tribunal. What is the citation? That is also not forthcoming here. Union Bank of India versus Bharat Bhushan. Testimony is submitted alla ತಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆ ಅಂತ ನಾನು ಹೇಳಿದ್ದೆ.
ಅದಿಲ್ಲ ನೋಡಿ ನಾನು ಭಾರತ ಐರನ್ ವರ್ಕ್ಸ್ ಅಂತ ಭಾರತ ಐರನ್ ವರ್ಕ್ಸ್ ಲೈಕ್ ಮಾಡ್ತಾರೆ ಫೈಟ್ಸ್ ಮಾಡ್ತಾರೆ ನಾನು
We want to look. We wanted to verify whether this Supreme Court judgment has been considered by the Delhi High Court and last time. That is this Firestone case.
73 Bharat Bhushan.
ಅದನ್ನೇನಾದ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರಾ ಅಂತ. This is 2015. You will check the other matters after summer vacation. Let it come after summer vacation. Yes. This is the matter. Vacations 2020. Which one, sir? No, in the morning at 10:30, someone sought for an adjournment, sir. Yes, you adjourn the matter. Yes, some inconvenience it seems. None it comes at. In the morning session, we have already adjourned it. Immediately, we have said immediately after summer vacations. We have already. No, sir. We have already dictated the orders. So by this time, it would have been already drawn. It we cannot consider it. 10:30 only. Someone mentioned. Yes. Yes,
Your Lordship, in serial number 25.
Yes.
I appear on behalf of the petitioners, Pandit Resorts. We haven't yet received.
Your submission. You want an adjournment? Huh? What you have not received? You are for the petitioner.
Yes, we are on behalf of the petitioners. We haven't yet received a reply from the respondents to our writ.
Why should you receive a reply from the respondent? You argue. Don't bank upon the weakness or the case of the respondent. You put forward your case. You are for the petitioner. Why
Yes,
why you want a reply from the other side for your petitions? They may file it or they may not file it.
Okay, Your
How
Lordship,
you are
accommodate us for with a short date as the senior is before the Supreme Court.
Huh?
Accommodate us with a short date, Your Lordship.
What you want to make it before the Supreme Court?
My senior is before the Supreme Court, so I'm sorting an adjournment.
Sorry, madam.
Am I audible, Your Lordship?
Yes, but the ground on which you are seeking an adjournment, we are not ready to accept it. Sorry, get ready to argue the matter.
Kindly pass over the matter. I'll seek instructions from my senior.
What is the final? What is the order challenged herein? It's not the final order. It's only the interim order. No representation for the appellant. Arguments on maintainability is not addressed. What is the order that you have challenged the writ petition? How this writ petition is maintainable at this length of time?
Your Lordship, kindly pass over the matter for 15-20 minutes.
It is only to encourage you. It is only to encourage you. We are asking you to read the prior column. It is an opportunity for you to argue the matter. In the absence of your senior, kindly open the file. Come to the prior column. Kindly read the prior.
Your Lordship, I don't have the paper book with me right now. I am at the court. So
you have to
kindly
steal
pass
the
over the
opportunity, madam. When your senior is not there, you make it as an opportunity for you to address the court.
I apologize for the same, but I don't have the paper book right now.
Pass over. We will not adjourn the matter.
Okay.
That matter will not relating to the acquisition. Where series of judgments affect that.
My lord, I appear for the respondent, my lord.
Yes,
My lord, my
sir.
profound apologies, my lord. I've not been able to get the information, my lord. I'm sorry. But my endeavor is to support and give as much as information as possible. I seek small intelligence, my lord. It's very short date, 2 weeks. In fact, I've escalated this matter with the BDA. If I'm not able to give it, my lord, then my lord can proceed further, my lord. I will have no voice. It's a humble request, my lord. Just a couple of weeks. I will surely go on with the matter. I will give all documents well in advance to my friend also. It's an assurance which I am saying. Please.
No, here humble request would not be suffice, sir. It should be supported by at least some exercise made by you.
My lord,
Certain extent, nothing.
in fact,
Except seeking adjournment on
my lord,
nothing it is moved.
My lord, in the course of the day, I will show the communications are done with the BDA, my lord. I've also sat with them. I will ensure it's done, my lord. It's a submission. I generally don't take adjournments, my lord, but I'm sorry, my lord, my hands are tied.
But in this case, you are repeatedly taking adjournment.
Yes, twice I've taken. Yes, my lord. I understand that the reason, my lord, is that it's all voluminous documents, my lord. We'll have to get from the government and also the old acquisition denotifications. That is the reason.
Of the year 2012. This petition is of the year 2012. 1 decade has already lapsed. If the BDA is not able to assist the court, then what action should be taken against BDA, sir?
Lord,
is it fair on the part of the BDA to come and seek for an adjournment at this length of time?
I understand, my lord. What my lord said is right, my lord. But my only endeavor would be next date of hearing, my lord. A date can be fixed. I will go on with this matter. It's only my request. I cannot ask anything more than this.
What they must produce?
No, it is our message to the BDA. Repeatedly changing the learned counsel. We have seen from the records that how many learned counsel have been changed for BDA in this matter.
Yes,
it is left to ultimately it is left to the discretion of the BDA to engage their counsel. We are not coming in the way, but it is not fair on the part of the statutory authority like BDA to keep on changing the learned counsel like this. And again, the learned counsel coming and making a request before the court. I'm newly engaged by the BDA. I have to collect the
yes, my lord. In fact, I appeared, I filed the statement of objections.
Yes,
that was not filed.
How many times the BDA has changed the learned counsel? On each and every time when there is change of learned counsel, this should be the submissions made by the learned counsel. Could it be considered, sir, with all fairness?
No, my lord, I understand, my lord. I have nothing much to say, my lord, but my lord, it's a prayer, my lord, I'm making.
We can make out what is there in your mind. We can make out easily, but we are not. Look at the file. From 2012, it is pending here.
Last 2 days, I don't know how they have picked and chosen in filing the appeal. They have withdrawn the appeal. They have withdrawn writ petitions are withdrawn because certain part of the land was left out of the acquisition during the pendency of the proceedings. And a series of orders passed by the learned single judgment which says that the scheme is not implemented, giving specific data, specific details, the extent. BDA itself did not file an appeal and they withdrew the appeal. They cannot not say, insofar as that case is concerned, I will accept that it is lapsed. But here we will contest. Therefore, your lordship had sought for all these details to be furnished as to why that writ petition lands were dropped and leading to its withdrawal.
Will adjourn it subject to payment of costs, sir.
Now, your lordship may direct the commissioner to be present and answer. They can't take a division bench of the constitutional court for a right. My learned friend says his hands are tied. Then, my lord, let the authority that himself come and
I didn't mean it on that ground. I said, my lord, immediately I'm not able to produce documents. But my lord, I'm following up personally in this matter.
When you will able to produce the documents, when you will able to trace it.
My lord, get the date mentioned exactly after 2 weeks. I will produce. If I do not produce, my lord, may order that matter will be taken.
Exactly after 2 weeks, there will be summer vacations.
Sorry, before that, before summer vacation. Before summer vacation.
Can you give adjournment? Give adjournment like this, sir. We have already given a long rope to you.
ಇದು ಒಂದ್ಸತಿ ಕೇಳ್ತೀನಿ ಸರ್ I will not ಮಾಡಲ್ಲ ಫೈನಲ್ ಅಷ್ಟೇ
You pay the cost, then subject to that field. You pay the cost of it is 5,000 for an adjournment. Right ಅಂತೀರಾ ಎಲ್ಲದು.
ಅಲ್ಲ ನಾನೇನ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ, ನಾನು ಕೊಡ್ತೀನಿ. I will pay from my pocket. I will pay it. I will pay it.
ನಾನೇನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, ಅದಕ್ಕೆ ಅವರೇ ಬಂದು
ಕೊಡ್ಬೇಕಾಗ್ತದೆ. It's a judicial. I will pay, my lord. I will pay.
That it counsel for the respondent number 2 BDA. A further 6 time.
have it on 18th or 19th. Proceedings ಆಗಿದೆ, ನಡೆದಿದೆ. 2-3 orders your lordship has passed. There should be some sanctity to court orders. 19th.
We deprecate the we deprecate the inaction of the BDA not complying the order dated 10/2022. And seeking adjournment for one or the other reason. However, justice and equity, we deem it appropriate to list the matter immediately after summer vacation 2022, subject to payment of cost of rupees liable to be paid to the Karnataka State Legal Services Authority within a period of 3.
Lordship may say that they must comply with the earlier direction.
2022 we have said so.
Last day, the earlier directions you specifically Lordship has said they must comply with it. Can you say that? They have not complied on the last 2 days, they have not complied.
It is made clear that it is made clear that the BDA shall comply with the directions issued by this court. As
on 10th of March.
On 10/3/2022, by the next date of hearing. These matters are adjourned, madam. The last petition submitted the same thing. Yes. No, that is not a reason for this court to adjourn the matter. The senior counsel may appear before the other high courts or before the other honorable Supreme Court. That is not the reason for this. When the matter is listed, you have to, some arrangement has to be made here. From 2015-16, these matters are pending here. It is nothing but a scant regard to this court. It's nothing but it is nothing but disregard to this court. That's all we can infer it. We are sorry to say so, madam. Yes. How many times we can keep on adjourning the matter like this? At your request only on the last occasions, the matter was listed to today. Learned counsel for the petitioner, yet further 6 times, list the matter immediately after summer vacation 2022 as prayed. This is also of similar nature. This is also of similar nature. Yes. Yes. Not from your side, from the government advocate. Yes. Have you received any instructions? Why, sir? Why? Who is the officer? You keep the Tahsildar present before you keep the Tahsildar present before the court on 13th March, 13th April. 18th. Tomorrow. Let it be on tomorrow. Release the matter at the request of the learned AGA. No, sir. Keep the officer present before the court. Whatever it is, you send it, sir. If the Tahsildar is behaving like this, if there is no response to the request made by the learned AGA, comply with the directions issued by the court. Yes, sir. Yes, sir. Sorry, sir. Release, no, not on 30. Release this matter on 12th. At the request of the learned AGA. Tahsildar. Who is the Tahsildar? If no instructions are issued to the learned AGA by tomorrow, Tahsildar Asantalu present before the court. Let him be present.
Engagement. Some interviews. In fact, he's in the hospital today. That's the reason I mentioned in the morning.
Sir, how many times this matter has been adjourned?
20 matter. It was posted, yes, in December on a number of occasions.
The connected matter is 2016 matter, sir.
After admission, it has not been listed till recently.
Yes.
And this today because Mr. Shankar is in the hospital today and he is engaged to appear in these matters. I should have mentioned that in the morning at 10:30. I didn't get to make that submission.
Whatever reason, sir, it's not fair on your part. You are also equally senior to argue the matter, and this in the connected matter, there is another matter connected with. Is the very same learned senior counsel is arguing in the connected matter also?
Yes.
Is the matter immediate after summer vacations 2022 as prayed. In the connected matter, learned AG accepts notice for the respondent No, instead of look at the order sheet. On the last occasion also, you time was sought by your colleague that you are not in station or you are some inconvenience to argue the matter. At your request only the matter was adjourned.
I only asked for time on this.
Yes.
Here, my lord, see, both the cases are clear. In one case, my lord, they are saying that my lord, the section 14 and 17 document.
Yes.
Now, my lord, in the second petition, which is filed by the assessee, he says that once the 14 is applied, 17 is excluded.
17 is partial rebate.
Partial rebate. This is the issue. As my lord, in the first matter, in my matter, my lord, matter has to go back was in none of the orders there is a clarity. They say only, my lord, there is a miscalculation. While, my lord, this is a arithmetical calculation. What is the wrong committed in while, my lord, calculating the availability, my lord, input tax credit available to them? What is the restriction which they input? Whether the formula has been, my lord, employed properly? Nobody has discussed. And in the second matter, my lord, they have on merits, my lord, they have raised one additional question that with regard to the limitation to review, to review.
Different SSC, not the same SSC. In my case,
issue is somewhat similar, my lord.
on merits, the issue is similar. In my case, in fact, for 8 SSCs apart from this one, the tribunal given findings, those findings have been accepted. No appeal filed for the 8 earlier years. This is the first year in which an appeal came, revision petition came to be filed. The tribunal has relied on the orders for earlier years. That's what I was taking through, my lords, in the last week. There were some workings to be made to show, because the issue, as my friend points out, is I purchased furnace oil. That furnace oil I use in the course of sales within the state of Karnataka, exports, and also stock transfer out. To the extent of stock transfer outside Karnataka, I am not eligible to claim the credit because there is no sale payable of the output. So I have to do a proportionate reduction of the ITC which I avail in the furnace. If it is not available, I have applied the formula under section 17, which is partial rebating, which is the ratio of the taxable sales to total sales. And the credit also should be apportioned in that formula. I have applied that. That's what has been blessed by the tribunal in earlier years also, and by the fact of non-appeal for 6-7 years. The department has also accepted this time. In this case, the department is now contending that when section 14, which is pressure rebating formula, more furnace oil is liable to purchase tax at 12.5%. Section 14 says that to the extent above 9.5 or 10%, you are ineligible to claim. So if I pay 12.5 rupees as tax on furnace oil, I can claim 10.5 rupees as credit. 2 rupees I cannot claim as credit. That is in excess. So same thing. So 2 rupees I cannot claim. Now what the SSC has done, and in my case and in other SSC's cases, is that 2 rupees I then apply section 17. The department says no. Once it falls under 14, you cannot claim the benefit of 17. In my case, that is very simply put. That is what has happened.
That's what they are containing now. SSC is containing the same.
That since there is commonality on merit,
my appeal has to be dismissed, then SSC appeal also has to go back.